Power Monday, you're tuned in and Dr. Antler FM 103.9, your station for knowledge and entertainment. It's 5 minutes gone past the hour of 1 o'clock. It's time for Policy State of the Nation. And today on Policy State of the Nation, we'll be taking a look at the Petroleum Industry Bill, looking at host community issues and the unbundling of the NNPC under the bill. And with us in the studio today to shed more light on this is a special guest. His name is Mr. Tolu Aderemi. And he is... Mr. Tolu Aderemi is a legal practitioner, a John Taylor Scholar of the University of Aberdeen, from where he holds a postgraduate degree in oil and gas law. He is a well-rounded lawyer with deep insight into the workings of the local and international energy industry, and has also garnered substantial experience and expertise in advising clients on commercial complex headline transactions and disputes spanning litigation and arbitration relating to power and oil and gas sectors. Mr. Aderemi has been involved in high-profile domestic and international energy transactions and litigation, as well as energy and commercial arbitrations. He advised Nigeria's leading smart electricity meter production company on its participation as a meter asset provider under Nigeria's mass smart metering program of the National Electricity Regulatory Commission. And he has held many voluntary positions, including, amongst others, the co-chair of the Lagos Chamber of Commerce and Industry Arbitration Committee, vice chairman training committee on section on business law, Nigerian Bar Association, a mentor for the Tony Elumelu Entrepreneurship Program, a national election observer for Nigeria's Independent Electoral Commission, INEC, and president of his LLM class at the University of Aberdeen, and secretary of the Student Representative Council at the Nigerian Law School. He's also an author and co-author and a regular speaker at both local and international conferences. You're most welcome to the show today, sir.
Thank you very much.
All right. So on Thursday, the 1st of June, the much anticipated bill for the Act to provide legal governance, regulatory and fiscal framework for the Nigerian petroleum industry, the development of host communities and for related matters 2020, otherwise known as the Petroleum Industry Bill, was passed by the Senate. And according to the oil industry players, this bill is expected to restore sanity in the management of the oil and gas sector, both downstream and upstream, and inspire investors' confidence. But let's, go to the background and the history of this bill. And the first question I will ask on the show is, what is the Petroleum Industry Bill?
Okay, thank you very much for having me. And just to provide slight updates, I'm now the chairman of the training committee of the NBSBL. Now to your question, I personally feel very excited and I feel very fulfilled that last Thursday or last Friday, Nigeria made history. We made history because this bill, from our end of participation, is about 13 years. In the days of Real One Lukman. Yeah. And this was fueled not only by the fact of looking to sanitizing the market, but also looking, like you rightly said, to inject investor confidence and create a market that is attractive, to the world. You don't want a market where it's convoluted and there's lack of clarity as to who your regulators are. And even where you know who your regulators are, what regulations do you follow? And then you also have an industry player who you're not entirely sure whether it's an industry player or is a government agency. And then that fellow plays in dual capacity. And then so it created a lot of problems. And so for 13 years, there's been the backs and forth to this legislation. But let me even tell you what is even far more important. It's important because, and I congratulate the National Assembly for doing this, because it's daring. So in the document you're looking at, it's a 234-page document.
Yes.
When you look at the committee report, it's about 437 pages. So I say the committee report reflects a bit more the substance of that legislation even more than the document itself. What do I mean? It's a combination of 16 legislations in the oil and gas sector that has been reduced into one. And I can mention a few of them.
Okay.
You have the Petroleum Act, you have the Drilling and Production Regulations, you have the Deep Offshore and Inland Basin Production Sharing Contract Act, and you can list them on. And so when all this started, we were very concerned. And I remember one of the past ministers of petroleum did say that we were ambitious. Because how do you condense 13 legislations into one document?
Yes.
For our part, because we've dealt with all the laws, but at the dispute resolution end, interpreting the clauses in the production sharing contracts, we could tell very easily that it is almost impossible to achieve this. If you take just one of those legislations, you will understand what I'm talking about. But do we say because it appears unachievable, we will not do it? No. Why so? Because we're losing revenue.
Yeah.
And so, do we start somehow, and then as we go along, we're able to amend the same? It's just like the American Constitution. It's a small document. Yearly or periodically, you are able to review it. So I think for me, that's the philosophy behind this petroleum industry bill. It is not a wholly satisfactory document, I must say. But it's a document that I think it's in the right direction.
Okay.
There are one or two issues that the National Assembly, they're still trying to harmonize. I'm trusting that the President will review it objectively and in the national interest and will sign it into law. So anything we're discussing this afternoon, I must quickly put in this caveat that we're discussing a bill that has been passed by the National Assembly,
Yes.
but has not been assented to by the President.
President.
So when the President assents to it, it might come out totally different. Don't forget, this has happened before.
Yeah.
We're on the journey again. But I have no doubt in my mind that looking at the areas of focus of this legislation, the President is duty bound to sign it.
Interesting.
Okay. What are the objectives of the bill, and what does the passage of the bill mean for the oil and gas sector?
Oh, very simply, the objective of the bill is to create a sane market, a Nigerian sane market. And secondly, is also to ensure that we have a proper governance structure. You see, one of the problems we have in the country, and it's a problem of investors, is their inability to identify who regulates what, and also what regulates what. So if you look at the oil and gas industry, you can also juxtapose it with the power sector. We are almost having similar problems there, where you have regulatory agencies with overlapping functions. And so what this bill has done is to correct that. So today you see that we now have a DPR who is a current regulator and who maybe, some people have taken the view that appears to be wielding, an overbearing stick on the sector. And a number of investors have been a bit uncomfortable with that. Not so much because of the overbearingness of that department, but sometimes even because of what appears to be lack of capacity in really digging down to proper regulation. Because the DPR regulates both the upstream, the midstream, and the downstream sectors. So what we have today in the PIB is the upstream, which is now called the Upstream Regulatory Commission, and then you now have the mid and downstream regulatory authority. Now you hived off these two responsibilities and obligations. They present their own challenges if you look at it, because there are some players who hover between the three areas, and then it's easier for them to meet one regulator and get all their approvals. So in DPR today, you have different departments, upstream, midstream, downstream. But now that we've separated it, what we're also trying to do is also invite sector or area-specific investors. So if you are skilled in midstream or you're skilled in downstream, we're inviting you to focus on that area. If you're skilled in upstream, we're inviting you to focus on the area. Because don't forget, part of the all objectives of this bill or law is also to develop our sector very properly. And so separating them in this manner, I think, achieves that purpose. The second important point there is also what you possibly can call the elephant in the room, which is some people have addressed them as a national oil company. Some have addressed them as the Nigerian National Petroleum Corporation. Some have addressed them as the cash cow. Call it by whatever name it is. But I say that institution is an institution that is most important to us as a country. It's also an institution that helps or propagates and projects us commercially before the world. And so organizing it properly and also putting it in a position where it can play on the same pedestal with the likes of the other IOCs, and also have the ability to attract funding, because one of the problems they may have today is what may appear to be an inability to attract funding. With the present construct of the PIB, and if we follow through very clearly, the new NNPC, which is going to be called the NNPC Limited, is going to be able to attract funding to fund its operations. As to his assets and his liabilities, I would like to know whether it's an area you want to go to, because those are very contentious areas. The bill already makes provision for it. It's not a new issue. We had it several years ago. I remember there was once we were invited to the National Assembly to make a public presentation. And one of the concerns was, how do you treat the assets and the liabilities of that corporation today? Because both are huge. So the assets are huge, the liabilities are also huge. Some are actual, some are contingent. But whether they're actual or contingent, they're already on the books of the company. And so it becomes very important how you deal with these liabilities. And what we had discussed at the time appears to be what is happening now, that the new assets, which is NNPC Limited, when created, will have or will inherit the assets of the old NNPC, as well as its liabilities. Now, that's, for me, was a very good compromise. Because one of the concerns of the IOCs was that, look, if we move assets and the liabilities don't follow, first in finance, assets and liabilities, they go together. But even in commercial reality of the industry, the reason why they go together is because the assets, now I use assets in terms of the company itself, is the entity that generates revenue. And so, how do you liquidate the debt, which is the liabilities of NNPC? It must be from the revenue that asset is generating. Now, if you hive off these liabilities into a separate company, the IOCs want to know, how do you fund that company? So I give you an example. In the power sector, we had the same problem. And what they did was they created an entity known as the Nigerian Electricity, I think, Liabilities Commission or something, NELCO. And that body was to warehouse the liabilities of old NEPA, which was almost 75 or 80% outstanding salaries. Now, what government did with that was to capitalize that company such that it starts liquidating the liabilities. Now, that gave those guys some sort of respite. Now, if we did that in the oil and gas industry, the IOCs want to be certain that wherever you're moving these liabilities to, that entity is also well capitalized to be able to offset the liabilities. For them, it makes sense to have those liabilities first follow the financial principle of assets and liabilities go together. Secondly, to also see that, look, it is the entity that is in petroleum operations that can generate revenue. It's only when that revenue is generated that these liabilities can be liquidated. And so that gives them some kind of assurance and confidence that, look, this liabilities is all right, keep it here. I know that at some point we're going to be able to liquidate it. And guess what? It's even to the benefit of the IOCs sometimes, because the liabilities sometimes are not paid in cash. So they are paid in quantum of oil. So again, that's a game of exchange value. So if today the value of crude oil is $100, by the time I'm getting a quantum of the percentage of my liability paid, it could be that price of crude oil may have jumped to 150. Ideally, what should have happened is that at Markham, you now come, and Markham is the management committee.
Yeah.
You now come to do reconciliation. And this is where accountability also comes in. But anyway, those are industry issues.
Okay. From what you've been saying, we've already delved into the unbundling of the NNPC. Okay. We would like to know what are the new entities that will be created. Okay, and then we also like to know if the institutional framework is strong enough to ensure the independence of those regulatory agencies, and again considering that the minister still maintains significant control.
Okay, thank you. The entities that will be created, the existing subsidiaries are going to remain, and then we're going to have what is now known as NNPC Limited.
Yeah.
Now, NNPC Limited is going to run or operate as a fully fledged commercial entity. Like your Shells, your Chevron, that entity will have the ability to trade. It will have the ability to sell crude on behalf of the federal government. The difference is that you now find an entity that is a bit more commercial now. So today, NNPC still sells on behalf of government, and perhaps maybe all that it gets is a retention of a percentage for administrative purposes. Now, under the PIB, it's now become very clear that it's a contractual engagement between this company and government. So if this company is going to be selling crude on behalf of government, then there's a percentage that comes to it. If it's also going to be negotiating the PACs, the production sharing contracts, and the JVs on behalf of government, and going to become an asset holder also on behalf of government, is going to be in a position to also charge for doing that. So there's now, what you call buying and selling. It's a pure market. And so the overbearing influence, if you like, as alleged, of government will no longer, be the case under the new NNPC Limited. It's going to run almost independent of government, and is expected to also generate revenue.
Okay, but the minister still maintains significant control. Is that not going to kind of interfere with the activities of the NNPC Limited?
No, it won't. The powers of the minister under the PIB, whilst appears to be enormous, has also been curtailed in a manner of speaking. So one of the main concerns of the powers of the minister is ability to grant or indeed revoke licenses or leases. And then under the current Petroleum Act, the minister, if you look at, I think it's 8G or so, has an omnibus power to do perhaps and undo. Now, under this PIB, those powers have been curtailed and made conditional. So they are conditional to the recommendation of the commission. That is the upstream regulatory commission that I told you. The DPR is divided into two parts now. So you have the upstream regulatory commission, you have the mid and downstream regulatory authority. So these two entities will now be almost the deciding authority to be recommending to the minister what the minister is expected to do and what is not expected. I think, of course, you may argue that, look, will the executive director, that's what it's called, of the commission say something to the minister, or the minister says something to him and he disagrees. That's a different. But the truth of the matter is, we're in a stage where the world is watching us, and our market must play competitively with the global market. Otherwise, we're going to be losing out of. And don't forget also that our laws in recent times have been tilting more towards the gas market. And in that market, there's a lot of sanity, regulatory sanity in that market. And if we want to take advantage of it, then we'll better do what we're doing now.
Okay, just before we go on break, what is the shareholding of the NNPC Limited going to be like? Who are going to be the shareholders? Thank
you very much. And again, I'm sure you'll be very excited with this response, because this is what the international community wants to hear. NNPC Limited is going to be held 100%. The shares of it is going to be held 100%. but divided between the Ministry of Finance Incorporated and then the Ministry of Petroleum Incorporated as well. Now, this is to show that these two entities, you can have some form of divestment and invite, investors to come and take equity in that company. So the two entities that I just mentioned perhaps may just be holding these shares in trust for the potential investors. I think the international community will be very excited about this.
Yeah, all right. So we're going to put a pause on it and take a quick break. And when we come back, we're going to continue the conversation right here on Policy State of the Nation. I do remember that you can be a part of the conversation. Yes, you can send a message via SMS or WhatsApp to 0703 2277 338. All right, we're going to take a quick break. And when we come back, the conversation continues. Don't go anywhere. This is Law FM 103.9. Welcome back. You're tuning in Lockdown to Law FM 103.9, your station for knowledge and entertainment. It's the policy state of the nation, and today we've been talking about the petroleum industry bill, the host communities, the issues with that, and also the unbundling of the NNPC. All right, and we do have a question here from Facebook, from Kazim Encyclopedia, and the question he's asking, it says, is it possible to have the federal government pull out of the NNPC totally?
Yes, it's possible. I want to believe that is what will happen in the long term. So the two entities that I did describe the other time that will be holding the shares, I did say they were going to be holding the shares. I mean, look at the power sector today.
Okay.
So the utilities, they also started out like this, and then you gradually have government sell off their shares. Now, why is it important for governments to remain there at this time is for reasons of stability. Anybody who is going to be investing also wants to be sure that, look, on the one hand, this has the imprimatur of the government, but with a view to having government, have an exit strategy. So ultimately, I think for us to achieve the long-term objective of this reorganization, we will eventually have government hands off that asset.
All right.
Okay. We'll just move on to the host community issues now. One of the issues the PIB, that's the Petroleum Industry Bill, is designed to address is the troubled relationship among the federal government, the oil companies, and the host communities. The troubled relationship is from the point of view of recognition of rights of the host communities. Okay, the bill promises to foster prosperity, economic and social benefits, and to, foster harmonious relationship with oil companies and to create a framework for sustainable development for the host communities. The issue, however, is the routes through which these broad objectives are to be achieved. Okay, so can you please talk to us about the establishment of the host community development fund and the 2.5% actual operating expenditure contribution from the companies?
Thank you very much, Sharon. I think it's important that we take a historical look at this question of host community issue, because each time we're at the cusp of passing the PIB, this issue will come up, and I say that, and with the greatest respect to anybody involved, the lack of understanding and the failure to investigate what has happened in the past is the reason why some of the issues we're dealing with today we had to deal with. Why do I say so? Matters of host community should first go back to the Petroleum Act. And I say this because the Petroleum Act defines our respective rights. Who holds these oil assets or the crude oil, and on whose behalf? So the Petroleum, this section 1 of it is very clear as to the role of government.
Yeah.
Now, our case is not like America, that if I find oil under my house, I own the right to that oil.
Yeah.
My only obligation is to pay taxes on whatever I do. That's not our law.
Yeah.
Our law is clear in section 1. And so therefore, the responsibility of government is to hold this resource on our behalf, and to also, even though this is not clearly stated, also be responsible for any environmental consequence operations may have caused. This is where issues around host community comes up. The agitators of the host community fund are not coming, they didn't start from an ownership perspective.
Okay.
They came out from a victim's perspective. So look, this resource is under our soil. Now, working on this resource is impacting us environmentally negatively, and government is not doing anything about it, or not doing sufficiently well about addressing it. And so that's a background. But we must also look at it from the government's angle as well. What has government done in recent years or in the past years to try to ameliorate this concern. Let me take you back to the 1977, in the days of Umpadek. Umpadek was set up for the purpose of cleaning up in the Niger Delta.
Yeah.
The River Basin Commission was also set up for that purpose. There is 13% derivation. 13% derivation is in addition to your monthly allocation if you're a littoral state. And my question is this: all of these initiatives were drawn towards a particular purpose. Did we achieve that purpose? The answer is no. And all of these, I must also add, costed the IOCs some money. It will continue to cost them because that's a responsible thing to do. But what they're contributing, how judiciously are we using it? And who is asking questions? So if I earn 13% in addition to my monthly allocation, what am I doing with that 13%? I look at Rivers State today, and I commend the governor of Rivers State. Every day is commissioning projects. People applaud him. I've never applauded him for once, because to my mind, he's just doing what a governor should do.
Yeah.
And he's not using his personal money, he's using the resource money. I expect every governor to follow what Governor Wike is doing. And then I expect people to also begin to ask questions as to what you're doing with these resources. So that's by way of history. Let's now come to the PIB. How has the PIB, or how will the PIB help this case? I think it's a balanced document. It recognizes the importance of the inhabitants of the littoral states, but it goes beyond that. It's now also recognized the importance of neighboring areas where oil facilities will normally pass through. So, for example, states that otherwise not littoral states, but you have pipelines pass through them. So they are called impacted communities.
Yes.
So it recognizes their rights. And what have they done? So there's now what you've described as the Host Community Development Fund.
Yeah.
That fund is almost similar to what you have as the GMOUs. That's the Global Memorandum of Understanding, which had been signed long before now between the IOCs and the communities. One of the challenges there might be is that it doesn't appear to me, and I stand to be corrected, that there is an organized community in those areas where you can hold, or that can hold the IOCs fully responsible. I know there have been cases out there, in Nigeria and abroad, of people who have come together to agitate, but they don't have one voice. And so if there's an opportunity to speak all with one voice, there's no reason why the GMOUs should not have been a success. But maybe the PIB is going to resolve it. So what has the PIB done? He's created the fund. He's also giving the residents or the inhabitants or the host communities almost what you possibly can call predominant relevance. Relevance in the sense that there's now a mandatory commitment from the settlor. The settlor here is the IOC, International Oil Company, operating in that area. And it's not just one settlor. So all the settlers, and so where you have an area where there are more than one IOC operating, the operator on behalf of all of them will act as a settlor. And so it will be the one representing all of them. And there's a mandatory commitment of 3%. Initially, there's an argument between 2.5 and 3%. But what is important is that it's a percentage of the previous year's operating cost of the books of that IOC. Now, why is this very important? And I think the littoral states and the agitators should start looking at things from this perspective. It becomes important because for the first time, we now have some level of certainty as to what comes to the Niger Delta community. We will come to administration of that funds, but the first part is what comes to us. Before now, under Emmanuel Boga, the former special advisor to President Yar'Adua, and I think maybe Jonathan, I can't remember, on petroleum matters, this started. And the mistake they made at the time was that they wanted to give 10% of they just wanted 10% to host community funds, to host communities. And there was an issue. 10% of what? Is it 10% of the asset? If it's 10% of the asset, then there's a problem. Why? Because it comes with assets as well as its liabilities.
Yeah.
So 10%, if we're going to share profit, I take 10% of that profit. What if there's a cash call? I'm also going to be contributing 10% of that cash call. That is where the unorganized community status now comes in. Who do you look to contribute that 10%?
Yeah.
So I think from then till now is a huge improvement of where we were and where we are now. Now, the Host Community Development Fund has mandated the said law to now set up a board of trustees. That board of trustees will largely belong to the host community.
Okay.
So they will, although the law also donates a lot of powers to the said law. So those powers will include powers to determine who comes on the board,
Exactly.
powers to remove who is on the board. Those are matters of company law, because once you set up, the constitution takes over. And so there's only a limit to the powers of the said law under that. But the law donates the power to the said law to appoint, to remove, to discipline, to do all sorts of things. But good point is the people that will be on the board, the trustees, will be members of the host community. So I think that's one. Number two is that the settler will also conduct an assessment, so it's called a needs assessment, of the projects required in each of the communities. Now, this I think should be tinkered with. Why? Because there's a similar provision for the members of the board to also be able to determine same. But if the owner of the board, let me call him the owner of the board, that is said law, determines or conducts the needs assessment, to what extent will the powers of the members of the board be potent? I say almost in the negative. So that area is an area that must be looked into. The board of trustees or members of the board of trustees should have uninhibited and unfettered powers to determine what projects, because it's their community and they know where the shoe pinches. What we should only ensure or enforce is the administration of the funds and accountability. Now, accountability in terms of project monitoring, I have not seen in the bill. So there is also a MACOM, it's called Management Committee. The Management Committee is to implement the decisions of the members of the Board of Trustees. But the sort of transparent, accountable structure I'm looking at is where the implementers, the MACOM, would also give an account to the board, and indeed the said law, as to what they've spent the money on. And the settler will be able to say, look, okay, money has been spent in the right direction, or it's not been spent in the right direction. But I think in the overall, I think the provision is, there's a lot more to it, but I think the provision is a step in the right direction. It balances the interests of both sides. We will do well to look at it a bit more closely. I know that there are issues around juxtaposing that with the commitment to the frontier areas. Again, those are matters that, like I said, it's like an American constitution. We will continue to improve on it.
Okay. I don't mean to take us away from what we're discussing, but from what you've said concerning the 2.5% contribution to the development trust fund, rather, what is the NDDC doing? Is it not like the same thing? Like, why do we have the NDDC and then we're having this now? And with the NDDC, has it worked? So what's going to happen to this new establishment?
Okay. The NDDC should have been part of the entities I should have mentioned earlier.
Okay.
That the inhabitants of the littoral states should call to ask questions. I don't live in the area, so I'm not able to speak to how much efficient and reliable the NDDC has been. I personally have not, other than the very big, humongous head office structure which they have constructed. I really can't tell, and there may be some trainings which, by reason of what I do, I am aware that they've conducted. I'm not sure to what extent, but it's just not NDDC. NDDC is, if you like, you can call it part of the problem, right? I know they may be doing some things, but maybe it's not satisfactory. What about the governors? So there are many of those things, there are many questions that even the communities themselves should ask questions. NEDC today is a going concern. It's still being funded from the budget of the Federation.
Yeah.
So what are they doing with that money? Those are questions that we need to ask. However, we must go this direction because we need to engender confidence in that market. And so if NEDC is not doing what it's doing, are we going to wait until it starts doing what it's supposed to do before we enact a law? Today, I've told you we have 13 laws that were brought together into one document. The international community must be excited about this because it brings together, it's also part of the ease of doing business.
Yeah.
And so for us, let's focus on deepening the market and making it attractive to the international community. All those internal issues are matters that we would, the government will deal with internally.
Okay, you talked about how it is now certain as to what the host communities would get.
Yeah.
Sorry. Okay, but there is this term, actual operating expenditure, which is where the contribution 2% is going to come from, and then this actual operating expenditure is left at the discretion of the company. So is it really clear or certain what that 2.5% is?
Yes. So I wasn't. I was clear when I referenced that that provision. The only thing, to my mind, that provision has done is that is brought certainty and clarity to the obligation of the settlor to the trust fund. How so? So the way you compute the books and accounts of an oil company is, so there's something called B1 and B2. The B1 looks to the past, the B2 looks to the future in computing what you've spent and what you're going to spend.
Yeah.
Now, what you spent and what you're going to spend also is a function of your lifting allocations. So what you've spent, you recover it back. You recover it in quantum of oil. And so because it may not have been clear what I'm going to do in future, so there's what is called an estimated value. But what I've spent in the past, which is my B1, is very clear. I have spent 100 naira. I have spent 200 naira. So operating costs, so it's called OPEX. There's also CAPEX.
Yeah.
So your CAPEX are your major investments. Your OPEX are your recurrent expenditure. Now, my recurrent expenditure is what I can capture on an annual basis. Now, that is also what I pay tax on, looking into the future. So I can only pay tax once it's ascertainable. And so which of those lines of revenue would you imagine or would you regard as being assured for the members of the littoral community? It must be what I can ascertain. So your operating expenditure, you would have captured it for last year. You would have known how much the cost of your employee salaries will cost. You would have known how much you're spending on trainings. You would have known almost everything.
Yeah.
And so if you know all of those things, you can apply this 2.5% to that cost and then be clear and ascertainable as to how much is going to come into the fund. If you leave it to futuristic expense, then the settlor can decide as to, and sometimes there may be the accusation, of inflating costs, etc., etc. So you really may not be able to tell what exactly will come to the host community for the purposes of infrastructural development.
All right.
Okay.
Okay, because our time is fast spent and we might have to draw the curtains on the show pretty
Sadly.
soon. Yeah, but in conclusion, right, the bill has gone through, several edits in order to properly capture the interests of the stakeholders. So looking at what we have today, would you say that that has been achieved? And would you also say that it's worth the wait?
I will say yes, it has been achieved, but I say that cautiously.
Okay.
I say it cautiously because I will expect the president, whose final decision determines whether it becomes a law or not, to consider the interest of the country first, and by so doing consider the market also second. So whatever the issues there may be, because at the moment I know there will be a lot of lobbying going on regarding what the parliament has passed, even the parliament is still looking at some other areas. So there are still areas around these host community issues, there are areas around the equalization fund. So they're still looking at it. And I'm sure that those are areas where they will perfect in the next few days and then also make those recommendations to the president. It certainly cannot be a perfect document, like I did say, but it's a document that, to my mind, as to all industry players, gives us almost about 70% or 65% comfort. Now, that is 15% above average.
Yeah.
So it gives us 65% comfort, and it helps us to even be able to give sensible advice to potential investors as to what to expect and where you what not to expect in terms of your investment. So I think first, we must applaud the National Assembly. Secondly, I think it was worth the wait. I personally, you would have thought that I drafted the bill where I was jumping on Friday, because I've written several articles on it. We've made presentations at the National Assembly, and largely because it also makes us look to the foreign community, to potential investors. It makes us look very bad and very, I'm looking for the right adjective to use, when we're not able to answer questions very simply. If you go to Ghana's laws is even far more robust. And so why is Nigeria, and we've been at this for how many years? Since 1956, Oloibiri, come on.
Okay, just before we go, do you think the bill is able to attract the right size and kind of investment into the Nigerian oil and gas sector?
Undoubtedly it will. Undoubtedly. Like I did say, when you look at NNPC Limited, you look at the construct of the law, you look at the intention of that provision, and we get the right people. So it talks of persons with not less than 15 years of cognate experience. We should get to a stage where, tribe regardless, what is important is we focus on merit, we focus on capacity. It doesn't matter whether it's a Yoruba that has a capacity, whether it's an Igbo, regardless of it. What we should be looking at is like what happens in the football industry. It doesn't matter if it's Igbo that can score the goal, they put Igbo on. So that's what I think we should focus on. And if we focus on that and we'll stick to the letters and the spirit of this legislation, give it a few months or years.
All right, interesting conversation. I want to thank you so much, Mr. Tolu Aderemi, for being on the show with us and for talking about this with us. I did mention earlier that Mr. Aderemi is a legal practitioner who has been involved in high-profile domestic and international energy transactions and litigations, as well as energy and commercial arbitrations. It was such a pleasure to have you on the show today.
Thank you very much.
All right, my name is Nikki Enabong, and of course the counsel in the studio with me was
Sharon Onunjoku.
All right. Of course, you know that coming up at 2 o'clock is Law 101 right here on your station for knowledge and entertainment. All right, so keep your dial locked on to Law FM because I said this is your station for knowledge
and entertainment.
Absolutely.